The Honourable Minister. Judith Collins.
Thank you, Mr Speaker. Mr Speaker, I move that the Trustee Public Trust Amendment Bill be now read for a second time, and since the House is an urgency, I don't wish to take too much time, but there have been some issues raised by members opposite, and I think that they deserve to be answered. For a start, I don't know, Ms Curran did ask whether or not I was rushing this through for some reason. Well, yes, the reason is very much I want to save the public trust, actually, and I'm not going to stand by, and I don't think Parliament wants us to stand by and let it be basically absolutely the taxpayer having to pay millions of dollars because of fund the public trust having to take on public responsibilities around trusteeships when this was never, ever intended. And I mean, a question was asked tonight, well, why wasn't this done before? Well, actually, in 114 years that the provision has been in the law for the public trust to be a trustee of last resort, in 114 years, Mr Speaker, nobody has ever sought before to make the public trustee the trustee of last resort for a corporate trustee failure. That's why. It has never been done before. Nobody ever thought this could be done, certainly in Parliament, no Minister of Justice, and in fact that's why. And as for the situation about, why now? Well, actually because the advice is we can't risk it. We can't risk it. And the case that's brought this to a head is the Capital Merchant Finance case, which is actually due to be heard in the High Court on the 6th of June. And of course this bill does not purport to apply to that case because I think that would be unfair. It's been in the court for some time, but the advice that I've been given is that we cannot risk it. And of course what's really happened in this case as well, which may not have been disclosed by me yet in the first reading, is that the receivers of Capital and Merchant Finance have sought to bring in and to hold account the trustees, the corporate trustees. That has therefore allowed the corporate trustees to say, actually strictly according to law, rightly, we have a conflict of interest and therefore can't retain the trusteeship of Capital Merchant Finance. So the action from the receivers, and I'm not criticising them for it, they're entitled to do that under the law, is something we've never seen before in actually in 114 years, so even longer, Mr Speaker, than you have been at this place. But in addition to that, only just, says Mr Hipkins. In addition, there's been some questions raised about, and I'll say too, is that the perpetual trustees, which are clearly not that perpetual, after this behaviour, they have 22 other failed finance companies that they are currently corporate trustee for. So we're looking in their case at 22. There are actually 60 failed finance companies that this could well apply to across the board, including those 22. So this is not a risk that I, as the Minister of Justice, believe is one that we can take to sit back and wait and see if this test case, which is before the court, is successful. It might be, it might not be. I can't risk it, and I don't think the public trust can risk it. An issue has been raised, I think, particularly by the Green member who spoke, as to whether or not this matter can be dealt with in some other way, whether or not we could have a select committee process. Because of the nature of what we're talking about, proceedings could be filed pretty quickly, particularly by a company or lawyers who are currently before the court right now on this on a similar matter. So I'm not really prepared to allow this to go on. We could possibly, Mr Mallard suggested some moves that we could say, well, it can go to a select committee and then come back and then have it backdated, the effect of it. I think whatever we do in this matter, Mr Speaker, we would be subject to criticism, either it be of a retrospective nature or the fact that we are moving to have this through an urgency. Whatever we do, we're going to be criticised. But I'm not prepared to stand back and let this happen and do nothing about it and then say, woe is me. But in addition to that, we also have, and this is, I think, the savour for those who are so worried about the process, and that is that the Financial Markets Conduct Bill is currently before Parliament. That bill is expected to be enacted in a few months' time, but it doesn't come into force until the 1st of April 2014. So the supplementary order paper to the Financial Markets Conduct Bill will provide a longer-term solution by permitting the Financial Markets Authority, or the FMA, to appoint a replacement trustee from amongst all available licensed trustees, so the public trust is treated equitably, and to require an indemnity from the resigning trustee as a precondition of the appointment. So this provides the longer-term solution. I make no bones about it. This is a stopgap measure, but it is one that we need to have in force. But when the Financial Markets Conduct Authority Bill comes through and becomes, in fact, takes effect from April next year, should it be passed by this Parliament, then that will in fact supersede what we're doing this evening. I would also like to take the opportunity, Mr. Speaker, just briefly to thank all parties for their support of this bill. I understand it's a very difficult situation, but I'm sure everyone here understands this is something that needs to happen. It's not the ideal situation, but frankly, we haven't been served up an ideal set of facts. So thank you, everybody. I know everyone has some concerns about some aspects, but in terms of process, but I hope that you understand and respect the fact that there is the Financial Markets Conduct Bill, and that will in fact take over from this provision. And I commend this bill to the House.
The question is that the motion be agreed to.
Mr. Speaker.
I call the honourable member Andrew Little.
Thank you, Mr. Speaker. Appreciate